I'm Henry Quillian. We're here at Taylor English Newman today, studying something that's going to be a very, very important legal issue. There's a brand new Georgia case from the Georgia Supreme Court that just came out that talks about the breadth of res judicata in Georgia. For those of you that are not lawyers, you probably have no idea what we're talking about. So one of the things you'll need to do if you get into a situation is, in this instance, you better go speak to a lawyer, because Taylor English is not intending to give you legal advice by way of this presentation today, but it is a very important issue that can get you thrown out of court if you are not careful, and it may affect the entire litigation that you have. Today our presentation is going to be made by two of my partners here at Taylor English, Bill Leonard and Don Boyle. They are people who have latched onto the issue of res judicata in recent times and have focused on this recent Georgia case, which they will present to you. As they will discuss, there are many factors that go into the determination of whether res judicata is going to impact your case or not. It's a fairly heavy-duty analysis. So, with that, I'd like to welcome Bill Leonard and Don Boyle. I'm not sure who is starting off or whether they're both doing this together right out of the bat. But do remember that you should consult your own attorney when you go to talk about res judicata in your case. Thank you very much. All right. Don Boyle.
Thanks, Henry. Bill and I are going to take this in parts. What I'm going to do is talk about what res judicata is generally. There's a Georgia statute on it, and I'll talk about the facts of this new Georgia Supreme Court case from June, why it's interesting, and then Bill will come in, and you'll see that there's, whether the earlier case was in federal court can be important, or even another state court can be important, and we'll talk about that. So basically the concept of res judicata is, if you've already had a chance to litigate an issue at a prior case, and it went to a judgment, you will often be barred from relitigating that issue or that claim in a second lawsuit. That's basically the concept. And that also goes to claims that you could have brought or should have brought in that earlier case. If it goes to a judgment, then you can't bring them up for the first time in the second case. That in general is what the concept is. Now in Georgia, it's been reduced to a statute, 91240 of the Georgia Code, the Georgia Code 91240. The judgment of the court of competent jurisdiction shall be conclusive between the same parties and their privies as to all matters put in issue, or which under the rules of law might have been put in issue, in the cause wherein the judgment was rendered, until the judgment is reversed or set aside. Now, a certain amount of legalese there, but it basically goes to what I was just saying, but a couple of key concepts are, it's got to be the same parties in two cases, or their privies, meaning people that, for legal reasons, are identified with parties in these cases, even if not named in those cases. And it applies as long as that first judgment is still a good judgment. If it's set aside, then the rule wouldn't apply. Now, actually Bill noticed a case report of this case that came out of the Supreme Court of Georgia June 29th this year called Coen v. CDC Software Corp. That case, got to give you the history, and this apparently is a well-litigated piece of litigation. These folks have been going at it in several forums and are still going. In May 2012, Mr. Coen filed a complaint against CDC Software Corp in state court in DeKalb County. He alleged claims of breach of contract, breach of duty of good faith, and sought attorney's fees and contractual indemnification. He said after CDC fired him, he didn't get a severance package that he was due. He did not allege any tort claims in this first lawsuit. On July 28, 2014, so the case has been pending over 2 years, the court entered final judgment in favor of Mr. Coen on his breach of contract and and some other claims that aren't specified. Then he got his attorney's fees the next month, August 2015. And then he voluntarily dismissed his remaining claims September 2015. So what happened next? Well, he went into federal court while that case was still pending and filed a second suit against CDC, a related company, and some individual executives. And that case ended up getting dismissed for lack of subject matter jurisdiction. So that's just sort of a footnote because that ends up not being relevant to the court's analysis, but that just goes to show you how hard these people are litigating. Then Mr. Coen files a third lawsuit. Now he goes into full Superior Court in March 2016. So here he is almost 2 years after, or a year and a half after he got that judgment in Cat County. And in this case, he said he was harmed by malicious and untrue statements made by CDC in a form that had filed with the SEC, a 6K report. He said these statements were defamation per se. And again, he had not made any tort claims in the first lawsuit, but here he made claims of defamation, false light, invasion of privacy, disclosure of private facts, etc.
John, am I correct that filing had been made with the SEC before he even brought the first breach of contract action?
Yes, that is true. So Judge Tom Campbell, dismissed the lawsuit on the basis of res judicata. The Court of Appeals affirmed, but in an unpublished opinion, as they do sometimes. They do an unpublished opinion. There were actually two different issues on appeal. Coen appealed, he said it should not have just been dismissed by res judicata, and Judge Campbell also had an alternative ruling. He said that he failed to state a claim. But the Court of Appeals only ruled on res judicata, so he affirmed that res judicata alone is enough to get rid of the case. So then it goes to the Supreme Court, which spent some time defining the proper standard of what res judicata is, and it reversed the Court of Appeals. Because it said under the proper standard, you have to have three prerequisites for res judicata. Identity of the cause of action, identity of the parties or their privies, and previous adjudication on the merits by a court of competent jurisdiction. And this is really the nub of it. The court said there has to be identity of the cause of action. What does that mean? The Supreme Court said it's the entire set of facts which give rise to an enforceable claim with special attention given to the wrong alleged. So that phrase, the entire set of facts, is really important. And again, it goes to the particular claim that the plaintiff is making. So the Supreme Court's reasoning was, because the entire set of facts required for his claims in the first suit did not encompass the entire set of facts required for his claims in the second suit. Because remember, he only sued for breach of contract, indemnification, etc. in the first suit. Second suit, he sued for defamation, right, based on the SEC file. So there were two different sets of facts. So they said the first suit did not bar the claim in the second suit. So the Court of Appeals was reversed, and it got remanded. So actually now the Court of Appeals has got the case again. So now the Court of Appeals has to decide was Judge Campbell correct to dismiss it for failure to state a claim. So, turn it back to Bill.
One thing that's interesting about this Coen case is that it clears up about 100 years of a situation where there are two lines of appellate authority on res judicata, and they've used slightly different standards in deciding what claims are barred and which claims are not. And it all stems, I think, from the case Watkins versus Lawton in 1882. The Georgia Supreme Court there defined the common law doctrine of res judicata and said a judgment is conclusive as to all matters put in issue or which under the rules of law might have been put in issue in a former suit between the same parties concerning the same subject matter in a court of competent jurisdiction. Well, when the Georgia legislature enacted a statute on res judicata, it drew exactly that language, except it left out concerning the same subject matter. So for a while, the Georgia appellate courts seemed to say, well, this is just an enactment of that case, and so they continued to apply the language of that case, and they continued to say that claims that concern the same subject matter were subject to being thrown out as barred by res judicata if the same subject matter of an earlier suit. Finally, many years later, Justice Welker dissented from a decision that found that a claim was barred and applying the same subject matter standard. And he pointed out in his dissent that, hey, that's not what the statute says. The statute doesn't even contain that language. And along the way, other courts, other cases in the appellate level started using, instead of the same subject matter, they said the same cause of action. And that standard seemed to be a little narrower and was less likely that we'll have res judicata applied to a second lawsuit. So what did the Coen court do? The Coen court looked at all these cases and said, yeah, you might think at first blush that there are two lines of cases, but we have looked at the facts of the cases and the actual decisions rendered, and we find them not to be inconsistent with each other. In essence, what they said was that the cases that announced this same subject matter standard, then when they're applying that standard, actually applied it more narrowly. And looking at the facts that they adjudicated and the actual ruling they made on those facts, they were not inconsistent with the other line of cases. So in doing that, they harmonized all the cases. They didn't have to overrule anything. As you know, courts hate to overrule older decisions. So by construing them that way, they harmonized everything and then announced the new standard that Don just described. So the Coen case does, I think, help not just harmonize the other cases, but it announces a better standard, a more understandable standard for res judicata. Now, one of the things we wanted to consider was how Georgia law compared with federal law. And I looked at only the 11th Circuit. I haven't tried to look beyond that. I didn't see any U.S. Supreme Court cases that clearly announced a uniform standard for construing res judicata. But in the 11th Circuit, there's a case, for example, that says, under 11th Circuit precedent, a claim will be barred by prior litigation if all four of the following elements are present. There is a final judgment on the merits. 2, the decision was rendered by a court of competent jurisdiction. 3, the parties or those in privity with them are identical in both suits. And 4, the same cause of action is involved in both cases. And in describing or applying that, they say, in general, if a case arises out of the same nucleus of operative fact or is based upon the same factual predicate as a former action, then the two cases are really the same claim or cause of action. So that's a much broader standard. Federal courts are much quicker to find that a claim in a second case should have been brought in the first case and bar it from being asserted in the second case. Yes.
The federal law of res judicata or the law of the state which rendered
That's federal law. Yeah, the underlying here, this was
federal court is trying to determine the res judicata effect of a state court decision. It applies federal law to that process.
These were the second case is pending in federal court, and I think in this instance the first case was also a federal court case.
The first case or a state court case.
So they were both, in that case, they were both false claim act cases under federal law. If the first case were a state court case, then I think, I honestly don't know.
I think the federal court actually applied the res judicata law of the state in which the state court case is rendered.
Yeah, that would make sense because you're construing the breadth of the decision of the first case. That would make sense.
The theory would dictate that.
I think it would, yeah. Now, in looking at the federal standard that they're announcing, it really is very much like that 1882 Georgia case. It's the common law that you got to if you went back to applying old Georgia common law doctrine of res judicata, it would be very, very similar to the federal doctrine. So what happened here is that the the Georgia legislature enacted a statute which takes precedent over the prior common law. It's just that they didn't describe the common law in exactly the same way, so the statute essentially narrowed the application of res judicata in Georgia. Oh, sorry, one more thing. One practical thing about that, if you are representing a plaintiff and you get brought in to file a lawsuit, there had been an earlier lawsuit, that you're concerned about res judicata, you're probably better off looking at going to state court rather than federal court if you have a choice. Conversely, if you're representing a defendant in that situation, if the lawsuit's filed in state court and you have any option to remove it to federal court, you might well want to do that. And if you can find a way to get the federal standard applied. Now, as we said earlier, you may not be able to do that. You may be bound to apply the earlier state court standard.
Before a bill leaves the stage and has Don enters the stage, because this might be a debate, the second part of the statute says, or which under the rules of law might have been put in issue in the cause wherein the judgment was rendered.
Yeah.
And the state court following the Civil Practice Act and the Uniform Superior Court rules, or Uniform State Court rules, allows extremely open amendment of pleadings up until the time a pretrial order is entered.
Right.
And they may never be a pretrial order. So theoretically, if you're trying facts or something within the realm of facts and the state court proceeding and then comes to a judgment, somebody can say, well, these facts are the same. It's just you never brought a cause of action based upon those facts.
Exactly.
Well, I think you have to have both. I mean, you have to give those facts, and there had to have been a claim in the first case that was actually adjudicated based on those facts. Now, the second case could involve the exact same operative facts, and then you potentially could have a res judicata bar.
But under the Coen case, they don't really address that part of they talk about cause of action, so they seem to try to limit it to the cause of action that was brought, but that's not what the statute says.
The statute speaks in terms of cause and doesn't say cause of action. In a footnote, the Coen court points out that at the time the statute was enacted, cause really referred to case, the plaintiff's case in the lawsuit, or the defendant's counterclaim case in the lawsuit, which is a little different than cause of action.
I'm actually going to back up and try again. If you look at the statute, it says, as to all matters put in issue or which under the rules might have been put in issue in the cause.
Right.
So it refers to the cause as the civil action, really.
Yeah, that's right, that's right.
So what's the matter that could be put in issue?
The statute says might have been put in issue, which seems broader to me than the Coen court's construction.
Yeah, that's what
Yeah. But they glossed right over that. They didn't deal with that at all. Julian?
When I read the last quote from the Coen case, it sounds as though they define cause of action as a set of facts. I always thought cause of action and claim were similar in that they were arising from the law that you would then apply to a set of facts. And in fact, in the 11th Circuit case here, it seems as though they do equate claim with cause of action, whereas in the Georgia case, cause of action is a set of facts. It's not a legal claim.
I didn't construe it that way. I think claim and cause of action are the same.
In Georgia?
In Georgia and in federal.
Well, I mean, I'm
Talk
just
about
looking at
cause
this,
and-
I didn't read the Coen case, but I'm looking at this quote, and it says, let's see. It says, if a case arises out of the same nucleus of operative facts, okay, where was it? sorry, I can't find it at the moment.
Right.
Oh. Okay, go ahead.
So in the first Coen case, it's a contract action. The second's a tort action, right?
Right. Right.
And I can see a different distinction there. If the first Coen case had been, say, a tort action for intentional infliction of emotional distress, and the second Coen action had been one for defamation, so they're both torts arising out of employment, do you think the Georgia Supreme Court would say there's no res judicata on that, since there are different facts that might be the basis of each claim?
Potentially, if the intentional infliction of emotional distress would have to arise out of something different than that filing with the SEC, for res judicata. If they both came out of that filing, then I think it would be res judicata.
Well,
Yeah, I'm just going to make the point. I mean, as I was saying, in my quote opinion, they say that you got to look at the entire set of facts relating to the wrong alleged. So if the facts to prove intentional infliction of emotional distress don't overlap with the defamation facts, then really res judicata doesn't apply, as I read.
well, that sort of begs the question. If you have a defamation claim, that the employer's agents made these comments about me, it's defamation, and that's suit number one.
Right.
And later on you bring, and he wins or loses, you bring a case for intentional infliction, and part of the facts are they made these nasty statements about me, but then they did other things. They sexually harassed me or whatever else goes into the intentional infliction. Res judicata or no?
I think probably not in this circumstance. Depends on really the details of how the facts are.
How many overlapping facts? If you have
Yeah.
half the facts overlapping, it's res judicata. If less than half, no res judicata.
Who knows?
Yeah, I found this, the quote from the Coen case that I was looking at earlier. It says, cause of action is the entire set of facts which give rise to an enforceable claim. It's quoting Morrison and another case. So, and that seems to be focused on the facts.
Right. I see.
Whereas a claim is something that arises from the law. It's a legal claim that is, then you look at the facts to see if the facts prove the legal claim. But in federal court, claim and cause of action, at least in the 11th Circuit, are synonymous.
Right. Well, I think under the federal rules and under the Civil Practice Act, the word claim was a replacement for the old cause of action. So I still see them as being synonymous in both state law and federal law. So, but I see your point about that case. Let me turn it back over to Don for the next phase.
All right. Although this wasn't the case in Coen, that the first case that's at issue was a federal case, a state case. Although I guess footnote to footnote, there was that federal suit that was pending for a while, but then just didn't seem to be relevant. So say, I think we've already come up with a discussion. So what if the first case is a federal judgment versus then you're in state court? What's the relevance of that? I think it's pertinent. I always like to look at the restatements. Sometimes our Georgia courts cite the restatements. I've got it here in the materials. They didn't really seem to be of any help as far as finding Georgia case precedents, but just for your information, restatement second of judgment, section 87, says you look at federal law to determine the effects, the res judicata effect of the federal court judgment. That's the restatement rule. But I haven't found a Georgia case citing it. And for what it's worth, if you go to the conflicts restatement, there's a similar principle, just a more general principle saying basically that the judgment of a particular court is supposed to be given the effect that court given. So supposedly, if you've got a court opinion from another state, say Maryland, you've got a judgment, the same parties are litigating in Georgia. Really, if the Georgia court's going to follow this restatement conflicts rule, on section 95, then they should look at the Maryland precedent and what effect to give that Maryland judgment. Now, as Mickey Ross has pointed out, shouldn't we be looking to federal court standard of res judicata in prior cases federal court? And really, that's pretty much what our Georgia courts have been doing. And at first that may seem inconsistent with Coen, but maybe it's just following the principle that you use the prior cases of federal case. You should look at federal law and res judicata. What I've got in the materials is a Supreme Court case from 1977, Coen v. City of Atlanta, where the court said the court will use, this court, Georgia Supreme Court, will use the same rules the federal court would have used in determining whether it would exercise dependent jurisdiction to determine whether claims are precluded by that prior federal judgment. So this is what the Supreme Court of Georgia said. If the federal court would have retained jurisdiction into the state claims, had they been raised, right, because the res judicata rule is claims you could have brought, then a subsequent suit in the state court would be barred by res judicata. But if the federal court would have refrained from exercising dependent jurisdiction, then the subsequent suit would not be barred by res judicata. Now, in the Coen case didn't try to address this one. They actually did have an interesting discussion in there about permissive joinder, which was, by pointing to permissive joinder, the Supreme Court said, look, if we use this broader rule so that basically anything that had anything to do with the dispute in the first case, you didn't bring it up, you can't bring it up in the second case. If that were the rule, which of course is not the rule of Van Amsterdam's narrow rule, if that were the rule, then that would seem to undercut the whole principle of having permissive joinder, meaning that you have certain claims in the case, and then you may bring in some unrelated claims to that case involving the same parties. Another case I thought was interesting from the Court of Appeals, Hardy v. Georgia Baptist Healthcare System, where there was a prior federal case, and then the second case involved a defamation claim not brought in the first case. The Court of Appeals said that defamation claim was barred by res judicata by the failure to bring it. Again, they're looking at the dependent jurisdiction rule, which of course is now part of the Title 28, 1367 supplemental jurisdiction rule in federal court. So they're looking at a common nucleus of operative facts under that rule, rather than the entire set of facts, operative facts rule that we have under the Coen case. So it seems to be a broader rule, but maybe the way to explain it is just that you have to look to the federal standard and what effect would federal courts give to their own judgments.
So along this idea of dependent jurisdiction evaluation, what if the federal court, which is generally less liberal than allowing you to amend your pleadings, more or less shut down your ability to amend your pleadings in the first federal case before you either learned about the fact that would otherwise have potentially led to a cause of action that could have been pursued in federal court, or alternatively, the fact happened after the close of the amendment of pleadings, but nevertheless, then you tried the federal case after you learned the facts. Right. Maybe even the facts came up during testimony, but they weren't tied to a cause of action.
I don't know. I mean, those are things. I mean, obviously, if you're a plaintiff in that second case and you're trying to keep your claims alive, to the extent that you can appeal the court's discretion at all with arguments like that, you want to do that. So what if?
Going back to your last question, I think if the first case is pending and the plaintiff then learns additional facts the plaintiff didn't know before that underlie a new claim, but the time has already expired for the plaintiff to amend his pleading in the first case, I don't see a problem under the Coen standard with asserting that as a second case. I don't think the plaintiff is barred when he doesn't even know about the claim. Yeah, and also, just as a practical matter, the Coen standard talks about the entire universe of operative facts, or I forgot now how they put it, but if there are new facts that give rise to a claim that didn't exist before that, then I don't see how you could say that the same universe of facts was involved in both. So I don't think Coen would find res judicata in that circumstance. Another hypothetical we looked at was, let's say the first case was dismissed with prejudice rather than having a judgment entered by the first judge. And I don't think that the result is any different there. The Georgia cases have said, here's one quoted, dismissal with prejudice is res judicata of all questions which might have been litigated in the action and is a final disposition, barring the right to bring another action on the same claim. So I don't think it matters whether it's a judgment of the court or a consent dismissal with prejudice pursuant to a settlement or any other reason. I did come across one case that I thought was a little peculiar, so I didn't put it in the materials, but just thinking about it now, it involved 3 surgeries. The plaintiff had an elective surgery, and about 6 or 8 months later had a second surgery to remove scar tissue, and then a few months later something went wrong with the implant that was the subject of the first surgery, and so that led to a third surgery. The plaintiff sued on the first surgery, but failed to attach an expert affidavit certifying that the defendant's conduct failed to meet the standard of care. So it got dismissed. Then the plaintiff filed a second lawsuit concerning the second and third surgeries, and also concerning the first surgery. The trial court dismissed all 3 claims based on res judicata. The Court of Appeals held that the first claim was indeed barred by res judicata, the one that sought to relitigate the first case. And Hal Meeks is here, you may be able to help me with this. That struck me as odd because I thought a dismissal for failure to attach an affidavit is without prejudice.
It's with prejudice.
Okay. All right, does the rule say that? I didn't see it in the rule. Okay, all right. So there is something in the statute though, I thought about if the statute of limitations hasn't expired, well, there's something in there about you don't get the extra 6 months to file a renewal action, which implied to me that if the statute hadn't expired at the time of dismissal, you could still refile. Is that not right?
I don't believe you can refile. If you file without an affidavit, that is fatal to your cause of action. If that's raised, the motion to dismiss, and when the motion is filed, the plaintiff has 30 days to come up with one, and they can petition. The court has the ability to give them an extension under certain circumstances. But I think it is a harsh penalty. But if you file without a 911 9.1 affidavit, then your claim is barred.
Okay. Well, in that case, what the Court of Appeals did with that one makes more sense. So they held that you could not relitigate the claim that had been dismissed for failure to file an affidavit. As to the other 2 claims, though, the Court of Appeals said, well, those are different surgeries, different circumstances. It's not tying it back to what happened in the first surgery. It's saying that the doctor committed malpractice in the second surgery and the third surgery, so that's not barred by res judicata.
Because med mal is defined as both the negligent conduct and the damage that it causes, and so the cause of action doesn't arise on the scar revision until the second surgery, and the cause of action doesn't arise until the third surgery if there's a subsequent development that gives rise to a claim there. So those are really new claims.
It's also worth keeping in mind that in Georgia, res judicata applies as soon as the judgment is entered in the trial court. As the statute says, unless it's reversed or overturned on appeal. The federal rule of res judicata is that it does not kick in until the judgment has become final after exhaustion of all appeals. So, in a hypothetical, you could have a federal court case where a judgment is entered against the plaintiff. It's on appeal. while it's on appeal, the plaintiff files exactly the same claim in state court in Georgia, I don't believe that it would be res judicata, because under federal law, the prior federal judgment has not become res judicata yet as long as it's on appeal. Wherever you flip it around, you have a different result. So that's just a lesson that I've learned, is when it becomes res judicata, it's different in federal and state court.
Let me ask you a question then. What happens if, after the second lawsuit is pending, the first one is affirmed on?
Then I think you could move to dismiss the second case under the federal law of res judicata, because under the federal law, it has now become res judicata.
Right.
But until the appeals are exhausted, the federal law is it's not res judicata.
So that makes sense. Julie?
I think we should probably mention that res judicata is not the only doctrine that would potentially prevent you from litigating a claim and subsequent litigation that relates to prior litigation. There's a doctrine of collateral estoppel. There's equitable estoppel. I know in federal courts I've dealt with those two doctrines. I'm not sure about Georgia.
There's a doctrine in Georgia called prior case pending, which basically says you can't have two cases pending at the same time involving the same claims.
There's also, I've seen federal cases that talk about a doctrine of splitting a claim, which seems to be, to me, very much like res judicata, but they treat it as a separate doctrine.
One of the things that bothers me when settling a case is, regardless of, no matter how much I know and may understand about the doctrine of res judicata, that some subsequent court, including any appellate court in Georgia, might totally disagree with my accurate interpretation of their previous cases that have come out. And so if I'm dismissing a case with prejudice, what steps can be taken to try, like in a settlement agreement, to try to make sure that it's well known that certain claims are not being precluded from a future litigation?
Well, I think that would be handled in the release language. You could make the release as broad or as narrow as you want.
But if the dismissal with prejudice is going to kill you anyway, then it doesn't do any good to have a narrow release.
You gotta carve it out of the judgment.
Yeah, I think it needs to be in the judgment itself.
And the
Or just have a dismissal without prejudice and have the release language in the settlement agreement take care of the problem.
But of course, an insurance company is never going to let you get paid anything without a dismissal with prejudice. So should you put it in the settlement agreement? This does not include this, does not include this?
I wouldn't stop there. I would, as Mickey said, I would put it in the judgment as well.
Don't suspenders.
Well, it will be a dismissal with prejudice. What kind of, can you have a dismissal with prejudice without,
But then expressly
with
exclude
limitation.
whatever claims you want to protect.
Yeah, that would be the way to do it.
and then has anybody ever gotten any money from an insurance company if you do that? Or they just say, hell no, we're taking it to
Well,
trial?
I've seen a lot of dismissal with prejudice that say, but does not dismiss any claims against the other defendants.
Yeah.
To avoid an argument that the defendants are going to try and piggyback on the dismissal with prejudice.
Well, I can certainly understand that.
Any other questions? All right, well, thank you for your attention.
All right, I think we need to give a big round of applause to our faint of heart. I need to be able to do some real splitting of hairs. Mickey?
I think they should do a follow-up on racism.
Thank you all for coming to Quillian's Kernels. Please keep an eye out on the web for our next subject matters.
Thank you.
Have a great day.